One of the most misunderstood patent documents is a provisional patent application. What is a provisional patent application? Let's talk about that. So one thing, if you take away anything from this video, if I say this next thing and you want to stop watching the video and shut it off, that's great. Just make sure that you take away this one thing from this video, this most important point, the most important point of this video. A provisional patent application is not an actual patent application. So many people misunderstand this important concept. I'm going to say it again. A provisional patent application is not an actual patent application. So I don't even like the term provisional patent application. A better term, in my opinion, for what it should be called is an invention disclosure. The provisional patent application is an invention disclosure. So the parts of a provisional patent application that are required to be filed are some type of a specification. It doesn't have to be in any particular format, and some type of drawings. Again, they don't have to be in any particular format. It's very lax in terms of the format that you can file this document in. And it doesn't require you to file any claims. You just have to identify yourself as an inventor, file a specification of some sort and drawings of some sort, and that's sufficient to get a filing date. So what is the point of the provisional application? The whole point is it's a placeholder for an early filing date. You want to get an early filing date. So when you file the provisional patent application, just like a regular utility application, it's assigned a filing date. And that filing date means that if somebody were to come along and file a patent application subsequent to your filing date, and your claims would be rejected because that patent application normally would have been used as prior art against your claims, you can knock that patent reference out as prior art because your filing date of your provisional is earlier than the reference that the examiner is citing. Now, I'll get into more details about that, but the other thing you have to understand about the provisional patent application is that you have a 1-year deadline to file an actual utility patent application, and that 1-year deadline, the clock starts ticking from the filing date of your provisional application. So if you file the provisional application on January 1st of 2023, you need to file your utility patent application by January 1st of 2024 in order to meet the 1-year deadline. Now, if you don't file the utility patent application by the 1-year deadline, your provisional patent application goes abandoned. So this is a timeline that represents the time that you're going to file your provisional patent application and the time that you're going to file your utility patent application. So on date X, you file your provisional patent application. Now, at date Y, another comes along and files a utility patent application. Notice I said the provisional is a patent application, in quotes, because as I mentioned, it's not a real patent application. At date Y, the other person or entity filed a real utility patent application after you filed your provisional. Their utility patent application is for the exact same subject matter as what you filed your provisional patent application for. Now, time ticks away, and within a year or less, you decide that you're going to file your patent application, your real utility patent application, and that patent application does what's called claiming priority. It claims priority to the provisional patent application that you filed on the earlier filing date. Well, as a result of you having met the requirements of filing the utility patent application within the 1-year period, that utility patent application is entitled to the earlier filing date of the provisional patent application. And so, when the USPTO examines the claims of your utility patent application and finds the patent application filed on date Y, they can't use that patent application as prior art to your claims because your filing date was X, which predates the Y filing date of the other person's patent application. Therefore, because of your provisional patent application, you saved your claims from being rejected by a reference that was filed after it, but before you filed the utility patent application. So that's the primary advantage of having filed the provisional application to have obtained the earlier filing date. Now, that said, when you go to file your utility patent application, oftentimes what happens is when you file the provisional patent application, you may not have had a full picture of what was required to implement the invention. Maybe you didn't have all the details worked out. And as you worked out more details, you added that subject matter to the utility patent application, or your patent attorney did. And now that subject matter may be subject matter that's claimed in the patent application, but it's possible that the provisional patent application did not provide enough legal support for the claims in the utility patent application because what's called new matter was added. And so that's something that you also have to be aware of and be careful about, is that if your provisional patent application didn't disclose sufficiently to support the claims that you want to try to obtain in your eventually filed utility patent application, and you have to add a lot of additional subject matter to support those claims, you may not be entitled to the earlier filing date of the provisional patent application. That's a danger that people that use the provisional patent application aren't fully aware of. And so, in general, my opinion about provisional patent applications is that you want to disclose as much subject matter as you're able to do at the time of the provisional filing. And also, if you can, you want to put it into a format that's as close to what the utility patent application is going to look like, or put it in a format that's going to support the claims as much as possible, even to the extent of drafting it as a fully complete utility patent application that only needs to get filed at the subsequent date. Now, it's understood that that may not be possible for various reasons. So, for example, let's say that you've got an idea that you think might be patentable subject matter. You're about to go to a trade show in a couple of days, and there just isn't time to prepare an adequate utility patent application. That would be a scenario where filing a provisional application would make sense, and you would file with whatever material you can, gather it up together, and get it filed. The format isn't going to be perfect, but at least you're going to have the possibility of having that earlier filing date, because once you disclose it, you're up against the danger of losing patentability. So having the provisional patent application on file in a format that's not fully in compliance with the utility patent application, in that scenario would be better than not filing it at all. So there are different scenarios where you would want to do that. Again, every circumstance is different, and so you have to look at the reason for why you're wanting to file a provisional patent application. Strategically, under the conditions that I've described, with a trade show coming up where you haven't fully fleshed out the invention, that would be one scenario, but there could be many others. So you want to look at the situation and see whether you really have time or not to prepare a proper utility patent application and get it filed. Now, the other advantage to the provisional is that, let's say that you are able to complete a utility application that's in the proper format with the claim sets that you're intending to get, but you're just not ready to start prosecuting the application. You need to do additional market research. You may need to do additional work for the for the business that's going to be the underlying business that's selling the product. There may be a number of things to do. And for that reason, it may not be sensible to incur the full cost of filing the patent application and going through the prosecution. And so from that standpoint, it might make sense to file a provisional and wait until you have the resources or gather the other information or materials you need before proceeding with the full patent application. So there's a number of reasons where a provisional patent application can be a useful tool to help you in building a patent portfolio and protecting your products and inventions. But again, it's a tool, and the most important thing, I'm going to emphasize it, even though I said it twice in this video, I'm going to say it one more time. A provisional patent application is not a patent application. It's an invention disclosure. It's a placeholder for an early filing date for an eventual real utility patent application that claims priority, and it must be filed within 1 year or less from the filing date of the provisional patent application.